my lord. Secretary had received, my lord. So, and after the motion,
Okay, we'll take it.
but
And constituent is there, they already must goes first.
May I please, Your Lordship? Yes, I beg to mention item number 6, Lordship, with consent of the other side. Matter may be listed on 18 November maybe. It's admission, but it will take time, Lordship.
Is it?
Your Lordship, my only prayer is that there's a stay operating, Your Lordship. So on the next date, adjournments may not be sought for Your Lordship.
Okay, you're for the.
Amicus curiae. Yes, Your Lordship. Respondent.
Take a earlier date, that's like.
Yes, yes, Your Lordship. I have-
Slightly earlier.
Maybe on 18. 18 November.
Saying the learned counsel for the petitioner seeks an adjournment. However, the learned amicus presenting respondent number 2 points out that there's a subsisting order of stay. The petitioner counsel seeks the next date on 18th.
18 November.
Just a minute, should I fix it a little earlier than that? Say
12, yeah.
13th,
12 maybe. On
hearing day, 13. 13, you will get more time. 13 is okay?
Yes, yes, Your Lordship.
13.
13.
13.
interim order, you know, maybe.
Interim order granted by the order dated so and so. Stands extended till the next date of listing, 13/11.
Oblige.
Obliged.
You know, it will be going away, confusion of, 13/11.
Oblige.
May I please, Your Lordship. Lordship, item number 19, Lordship. Lordship, FSL report was called for, Lordship. Case diary is already available,
Okay.
but as per my instruction, FSL is not available. Along
Oh, should we-
FSL along with one other report which was called for, both the reports are not available, Lordship.
Yes, Lordship.
We'll keep it pending, this CD pending
Lordship, I have to send back the CD.
and, okay, interim orders there?
No, Lordship.
No, no. So should we fix another date?
Yes.
The case diary is available, but FSL is await issue reminder instead. The CD may be returned back and procured again
Lordship.
the next date. List on
14th, Lordship.
14.
14, it will be too long, Lordship, without interim. Lordship.
You work it out. 10, 10, 11,
Lordship.
10.
Lordship, maybe on 7, Lordship.
10th of November.
Ten.
No,
Okay, Lordship, 10th.
10.
Lordship, I beg to mention for listing bail application, Your Lordship, for motion, Your Lordship.
Which day?
Uh,
Tomorrow?
on Wednesday, Your Lordship. Oblige.
Now, please, Your Lordship, I beg to mention bail application, listing for bail
List.
application.
Next week?
4th of November. One more, Lordship. Listing for criminal appeal along with IA,
Which day?
4th of November. see.
Fourth. Can that be on 6th?
Okay.
1 and 4, 1 on 6th.
Okay, sir. Oblige, sir.
May I please, Your Lordship. Lordship, similar matter is fixed on 12/11/25, Lordship. White BA number 3511/25, Lordship. Same order may be passed. Lordship. Matter may be tagged. Lordship.
Call for the case diary of Satgaon PS 17025. List on 12/11.
12/11.
12/11 along with
BA number 3511/25. Deeply obliged.
the boy a bit faster.
Lordship, it's a POXO matter and charge sheet has already been filed, Your Lordship. Today I'm only praying for notice, Your Lordship. I'm not in this matter.
No, sir.
This year maybe also called for, Lordship.
Okay, don't worry. Call for the scan case record within the bracket, case diary, charge sheet, medical report, etc. It's trial has not started, no, as per your instruction. Are you in a position to say that? Anyway, and another relevant
That trial has commenced, Your Lordship.
deposition, if any. Special POXO case 73 of 24. Within bracket, like Dudnoy PS 35 of 24. From the court of the special judge Gwalpara. Is the matter on. You suggest me a date.
my lord, on 16/11, my lord.
16/11.
16/11.
16.
Yes.
Supply 9, or supply to 9, supply is.
May I please?
Tell.
Dr. Kindly see page 27. Page 27. Lordship, co-accused already released on bail under section 483, Lordship, and present petitioner before your Lordship 482, Lordship. Case is charge sheeted, Lordship. So, Lordship, we may be allowed to participate the trial. This is our prayer. Lordship.
Because of the assault, ultimately unborn child expired,
Yeah,
and for which section 92
that is,
Yes.
it has been charge sheeted. no?
Yes, sir.
So then you let them go now. This both are ladies.
Yes.
So it will, our order, sir. BA, page 26. Page 26. The first two paragraphs. It is submitted by the learned counsel that three other co-accused were granted regular bail by this court on 13/8/2025 after completion of investigation resulting in a charge sheet. Full stop. The given facts and circumstances, perhaps the pre-trial detention of the present petitioners may not be necessary at this stage of the case. Accordingly, allowing this bail petition, it is directed, this is on a 20,000 each, severity of like amount each to the satisfaction of civil authority. Available for trial, not the hampered by any condition. The petition stands disposed of.
May please, your lordship. My lord, petitioner paying clearance bail against the PRC case, my lord. My lord, he is willing to
South Salmara 41.
41.
Earlier matter, any?
Earlier matter is also South Salmara 41.
Okay.
Same, this is also same PSPs.
Same case. Accused number, my lord, 1, 4 and 6 already, my lord, granted bail, my lord.
Your lordship
Regular
may
bail.
kindly page 19.
This is AB or BA?
AB, both
AB.
earlier also AB, this is also.
Okay, but we are getting it, we have to give the same order.
Yes. I am just pointing out that whatever there in page 19 of this search sheet, ultimately search sheet file under section 61 to 1152, 92 and 3 and 5, because of that assault, ultimately
yes.
that unborn child died.
Unfortunately. How many petitioners here?
My lord, 1.
One petitioner. Single order to go. Regular order. Okay, same order.
Highly obliged.
Allowed. Supposed to. Into 24. You have more mixes in. What I do? First matter will take,
Yes.
we can take up the first matter. Pending for a long time.
Yeah, my lord.
I've made some submissions, remember, but. Okay. Just get, go back.
Yeah, my lord, not the tiger poaching, my lord. Only, my lord, his
Yeah.
grandfather's time, he was having it. Violation of section 48. If you have, my lord, trophies like that at home, my lord, you are to apply for a, my lord, a license, my lord. He did not apply for it, my lord, so would be liable to be prosecuted under section 51. 36 days in custody, my lord. And my lord, not a case of poaching, my lord, that repeated of those things are missing, my lord. Absolutely, my lord. From his grandfather's time, he was having it.
And my lord, it is schedule 1 and 2 animal, my lord, the items recovered from his
Yes, yes.
residence, my lord. And my lord, in his statement, my lord, it is recorded under, my lord, 50 subpara 9 of the Wildlife Protection Act, my lord. And lordship knows that, my lord, it is admissible in the trial, my lord.
Before forest official.
Yes,
Yes, my lord.
yes, my lord. And my lord, he admitted, my lord, that all these things they recovered. And my lord, some people, my lord, they are different person, my lord, supplied him on different time. But it is recovered from his residence, my lord. My lord, it is an offense under 51
Yes, my lord.
Protection Act, my lord. My lord.
My lord, on the top of it, my lord, 58 violation is absolute, my lord. And that
58.
58, my lord. That is flows from Article 21 and 22, my lord. And thereafter, my lord, lordship said one thing, my lord, that it has to be there in, I have found out, my lord, that if there is a delay of production not within 24 hours, it is to be reflected in the forwarding report. That is also missing here, my lord.
Okay.
So apparent violation of 58, my lord, flowing from 21 and 22, my lord. It will be made. Although not 47 and 48, my lordship knows that authority, my lord, wherein, my lord, these lines are very beautiful, my lord, of course, my lord. Can I just?
Yeah.
এখন দি দিয়াচোন পটকৈ কৰি দিওঁ নেকি এইটো এই paragraph খিনি আছে
Ravindra. Ravindran judgment.
yes, my lord.
That's a very good judgment.
My lord, 17.9, my lord.
Of Ravindran.
Ravindran, my lord, it been off-quoted, my lord, in several authorities, my lord. Should I, my lord? Additionally, it is well settled that in a case of ambiguity in the construction of a penal statute, the court must favor the interpretation which lean towards protecting the rights of the accused, given the ubiquitous power disparity between the individual and the accused and the state machinery, because state machinery is always on a higher pedestal. Thus, this is applicable not only in case of substantive penal statute, but also in the case of procedure providing for the curtailment of the liberty of an accused. It is exactly a procedure providing for the curtailment of liberty of an accused, my lord. And earlier authorities, my lord, on this, exactly, my lord, violation of 58, those we have placed, my lord.
Those materials have been seized also, right?
It is absolute, my lord, no.
Can we release?
Seized.
Heard, Mahajan, Learned Council. Mahajan, Learned Councils for the petition. The petitioner is N. V. Sharma, Learned Special Public Prosecutor, Wildlife Officer.
My lord.
For the Forest Department, for 483 bail application seeking regular bail for the accused Anuram Deka, in connection with offense number so and so. Offense number KNPR/0225 for the Wildlife Act. The list of the allegations in the alleged forest offense in the is recovery of skins of Royal Bengal tiger, 4 numbers of semicolon, 4 numbers of canines, semicolon, 12 numbers of teeth, semicolon, 8 numbers of suspected deer skins from unidentified deer species from the residence of the accused. It is alleged that all these articles belong to prohibited categories of the Wildlife Protection Act 1972, finding their place in Schedule 1 and 2 thereof. learned counsel for the petitioner has has submitted that he has already spent 36 days in detention after his arrest. And that the notice under 50A CRPC, 50A,
58 matlab produced after the expiry of 24 hours.
that's, and that there was also, and that the production of the accused after his arrest before the concerned magistrate also exceeded the stipulated period of 24 hours, thereby vitiating his continued detention. The learned special public prosecutor, it is called offense case diary.
My lord,
Offense.
offense report, my lord, the number is also there, my lord, in the first page, my lord.
Yes. The learned special public prosecutor
84.
submits the offense report. It is not disputed that the alleged prohibited wildlife articles have been already seized. Good stuff. It is submitted by the learned prosecution that the statement of the accused has also been recorded. In the given facts and circumstances, I am of the considered view that perhaps the further under trial detention of the accused may not be necessary at this stage. In such view of the matter, he is allowed to go on bail of rupees 30,000
My lord,
One-
my lord.
on security of the right amount to satisfaction of the.
Kamrup Metro, my lord.
And subject to the condition that this investigation is going on,
My lord, going on,
going on.
going on.
Cooperate with the remaining investigation. And he shall not hamper or temper dividends. He shall not commit any illegal activities. Earlier, we allowed and disposed of.
My objection is recorded, my lord.
Yes, yes.
My-
Learned special PP objects to the grant of bail.
Highly obliged, my lord. Obliged.
Earlier, people used to have those things na, in their houses.
Exactly, my
At
lord.
that time, license was not.
Not necessary.
Yes, yes. Sir.
Obliged.
Petitioner. Behind command lagya hota hai. Radio pare. No. Radio pare. Mini shop radio pare. Kita mausa ni bisa. Radio pare. Ready. Next.
May it please, your lordships. Criminal petition for quashing of an FIR, which is second of its nature. Lordship will find the order dated 10/5/2024. What 10/5?
10/5,
Lordship,
10/5/24 should be here.
12/3/2024. The proceeding was staged and record was called for. Last second paragraph, in view of the above, the interim proceeding of the investigation of the Hathigaon PS so and so shall remain stayed until further order. The next line, your lordship, should be disturbing. Let the first FR from Gwalpara, because the first FR was lodged at Gwalpara, that culminated into FR.
Mhm.
Now, FR of Gwalpara PS be called for in connection with Hathigaon PS. So most probably no record has come yet. Because these are two separate records. Gwalpara FR is separate record and Hathigaon PS is separate.
It's.
Both the record has to be called for.
Both.
Both the record.
Record has come, but so.
No,
No, my lord, that my lord senior has submitted, my lord. Otherwise, my lord, records are not available, my lord. So we need to peruse that, my lord.
Stop. Here, the learned counsel has drawn my attention to order dated 12/3/2024. Passed earlier by this court. final report from, what is the Golpara PS case number?
Lordship,
That would be, don't you think that would be necessary?
it is necessary, that would be necessary because
It's not reflected here, so.
Valpara PS case number 414
Call for the
2020.
final report of Golpara PS case number 414 of
2020,
2020.
20.
2020. And also, also the
Hatigao PS 57 of 23.
case diary of this,
Case diary,
Case
because
diary.
investigation has been staged, so case
Oh, I
diary will be there,
the case diary of Hatigam PS case number 57 of 2023.
Lordship.
Write this order dated 12/3/2024. The investigation of Hatigam PS 57 is under an order of stay. The interim order shall stand
And-
extended to the next date of listing.
Deeply.
Get the date. Work out the date.
My lord, it's from Hatigao, any convenient date, lordship?
After 3 weeks or something, no?
Any date, any day.
Your investigation is in progress. 2011,
Lord.
2011,
My lord.
Lordship.
just randomly answers.
May I please?
Seven to police, sir.
Item number 7, 8 and 9 are connected, my lord.
Connected.
And on last occasion, my lord, the scan copy was called for, my lord. Whether the
7,
scan
8,
copy is, my lord, received or not.
Here in this case, lordship, I have been
Nine,
informed
no,
by
no,
the
not
registry that in the order, it is not written that from the concerned group. Probably because of that, they have not sent. They have forwarded the copy to the PP. lord.
So my lord,
My only prayer is at this stage, lordship may observe that from the court of special judge Kamrup Amingdao, these
Amingdao.
records may be called for.
We failed to mention that.
Lordship, the now charge sheet is submitted, lordship.
I see. Sarshid also we have said.
But that,
Stop. Okay.
7, 8.
The case record, call for the issue fresh requisition for the scanned copy of the case diary and charge sheet of North Guwahati PS case number 36 of 2025 to be requisitioned from the Court of the Learned Special Judge.
Ismail Judge, Kamrup Amingdao.
Special Judge. To be NDPS, right? So Special Judge. basically.
Now it is lordship LDPS case number 54 of 25.
Within bracket, NDPS case number 57,
54.
54 of 25.
54 of 25 from the Court of the, it
Special-
may be in sessions or additional sessions also.
There is
Right.
special judge.
From special judge, the special judge,
Kamrup.
coming down, they will find out. The accused persons are in custody since 11/4/2025.
Yes.
Same date of detention.
Yes, yes, same, same, same.
So list the matter on
on my lord,
the key order. within the-
Next week, any date?
1811, my lord.
Is it
It
okay?
will be too long.
If you want it earlier.
On 13 then, my lord.
13?
13. Was it 13? Yeah.
13.
Operation.
All right.
May I please, your lordship?
Yeah, please.
Mr. KL is on legs, your lordship. Kindly pass on.
After some time.
Yes, your lordship.
You connected. Yeah, no problem. We'll take it out after.
11, my lord, as per my instructions, search sheet submitted in this case, my lord. Case is under section 22C of the NDPS Act, my lord.
We have called for the case diary and charge sheet also
Yes, my lord.
earlier on the last 14/10. We have already called.
Oh, yes, my lord, they are not received.
It's not received.
Not yet.
We'll have to issue a reminder.
For 177 days.
Yes, I understand. 22C, so we have to call for the record. Good stuff. Issue fresh reminder for the scanned copy of case diary and charge sheet of Matia PS case number 35 of 2025. Is there any NDPS number in the meantime? If you have, that will help. It will be from Golpara, right? Special Judge Golpara. Special Judge Golpara. DPS Golpara. The accused is in custody since 5/5/2025. List the matter on. Let it be
On
on
my
13,
lord, 16, 16, 11.
13, 16,
16.
13,
11.
16?
16, 11.
Holiday.
Before it,
On,
before,
16 is Sunday.
before 6.
on 19, 11.
Lordship before 16 amended, Lordship.
You want before 60? Then let it be on 13, 14.
14.
14. Acknowledged.
May I please, your lordship? So in this case, I'm in interim bail, my lord.
Hmm.
LCR was called for.
Not yet received, my lord.
Here was the order dated 26/9/2025. The case record is not yet received. Issue reminder. Full stop. The interim bail granted by the order dated 26/9/25 shall stand extended till next date of listing. Okay?
Mal-
2011, my lord. Already he's in interim. my lord.
2011.
2011.
2011.
Mal-
May I please the lordship, my lord? I think 13 and 14 are same, my lord.
Payment.
Lordship, search said not submit, Lordship. Department file extension petition, Lordship, for 90 days, Lordship.
Statutory period is over, Lordship. On 29/10, they were arrested on 2/5/2025. On 29/10, statutory period expired.
That's fair, fairly something. Yes, they will be entitled to the commercial quantity.
Commercial quantity.
Commercial quantity statutory period is how much?
180
180
days.
days.
180.
It can be extended.
It can be extended
90 days.
if order is passed.
60 days and 180.
90 days, Lordship.
Within the statutory period, there was no order of extension. There is no order. of-
No, actually, when was the application filed? There is a slight catch here, actually. The statutory application, application for extension was filed before expiry or after expiry?
Before expiry, Lordship.
And is it disposed of? I mean, are you in a position to say that?
Lordship, I received order 27/10, Lordship.
Because, hey, matter citation to protocol, that's Rabindran case, na, Central Intelligence.
Yes.
This point has been looked into, actually. There was a
Right, wait.
confusion for this. Citation আমি চাইছিলো যে মাত্ৰ Rabindran.
It can be extended
uh,
only if the public prosecutor submits a report
Yes, yes.
along with the.
Report.
On mere application, it cannot be done.
Report. It has to
Report.
be,
36.
the application for extension has to be accompanied by a report of the
Report.
public prosecutor.
The
Based-
proviso
He can take instructions from IO, but there has to be a report of public prosecutor.
prosecutor.
It has to be filed within, something which is expired cannot be extended. It has to be filed within the statutory period. However, I think in Rabindran, what was laid down was that even if the extension is made after the expiry, it will be valid, but provided the application is filed within that period. So this fact we have to just find out, right? So let me see this. He was arrested on
2/5/2025. I am in 14. Item
Page
number
four, page
14. T266.
on the same day.
Arrest was the same day, but the grounds are different.
That's different. Different. Page 14.
Page 14, Lordship.
Page 14 is here.
Page 14 is the complaint. Lordship is holding item number 13 or 14. It is
13.
13.
Yes, 13.
Okay. আপনার arrest number page to In
Am I on the right file? 30. Arrested on 2/5.
2/5.
quite aware of the special judge.
It was recovered from the dashboard of the vehicle on being known by the driver of the vehicle. To start with, complaint
Okay, okay, so they have extended the period, no? It was on the day of expiry, they have extended. The thing is that, in this order,
My instruction is that till 129, 180, that it was not extended.
you have a copy. You should have a, kindly show, you will give a copy. This is the only copy you have. You can have a look. Because, the learned judges said that, through the learned PP, special PP citing valid and reasonable grounds. So that again will be a separate cause of action, maybe. Not if the extension is to be challenged, whether it was properly extended. But otherwise, a default bail aspect perhaps, you know. Sure, let's have a look. Otherwise, we can see it on merits always.
Provision considering that the custom was filed the petition.
It is submitted by the learned counsel to the petitioner that
has been-
though
yes.
the penal provision pertaining to commercial quantity has been given. And
It
the
has been
applicable
extended.
Statutory period is 180 days. But perhaps the statutory period is already over and charge sheet has not been submitted. Yeah, you tell me.
Lordship,
No, I'm not dictating finally.
yes,
That's
yes,
one part only.
And I think-
However, the learned Kakoti, learned counsel for the Customs Department, which is the prosecuting agency, has placed before this court an order dated 27/10/2025, passed by the learned special judge Kasar Silchar. I perused the said order in which it is stated that the statutory period, the initial statutory period was expiring on 27/10/2025. And the application of the prosecution through the learned special PP was filed on 24/10/2025. And upon perusing the grounds thereof, the learned special judge was pleased to extend the statutory period by a period of 90 days. Now, this is the facts as of now. The accused is stated to have been arrested on 2/5/2025. Should we see it on merits then?
Yes, Lordship.
Because if you are aggrieved by the extension, or you think that the extension was improperly made, that would be a separate cause of action, I think.
The Lordship,
Will that be a separate cause of action?
perhaps if extension is illegal, it can be decided in this case also.
Bail also,
This case is bail also.
maybe.
But there is no order for extension. Of course, they have filed it.
There is
application.
an order. In this order.
No, by this order, it has not been extended.
Right, he
It is
has
fixed for hearing,
extended. Not extended.
not extended. It is fixed for hearing.
But 90 days, I think you have seen something.
90 days. Itu page. Itu
27/10.
This is দেখা যাবে।
Second page lordship,
It is fixed for hearing.
students. First two lines lordship.
Yeah, period, yeah. The period is extended for further period of 3 months. It is optional. Please have a look at this. Call for the records then. You have to call for the record then. Then, yeah, you're right, actually. It can be challenged by a criminal petition. It can be challenged by bail. Technically, actually, the extension order is actually a criminal court order. Which
Yes.
is, if invalid, if it is, which if invalid, will entitle the person to bail automatically. But in a bail, whether we can go into that, maybe.
Like if it is extended lordship, one thing is apparent, it is not in terms of provisor to the section 36A subsection 4. There was no report of the IO, this public prosecutor.
So should we call for the, no, he has referred, but
Yes.
whether that is sufficient or not, that we don't know from this order. From this order, we cannot.
Yes, yes.
We
That-
cannot say, none of us can say.
That
Whether it
is
is
short date
sufficient
may
or
be
not,
fixed.
but that the learned court has said, that there is a reference to the application and the.
It has been filed.
Grounds given by the special PB. So we'll need the record. Let us get the record. We can see
Okay.
this aspect as well as the merit aspect.
Yes, yes, yes.
So, in view of the aforesaid, facts and circumstances, perusal of the record, case record would be necessary accordingly. Issue requisition for, I think we did not follow it before. Not, it's not come for first time, no?
No, no. Today case diary also supposed to be produced. They have not produced a case diary, but this one is produced.
You'll produce the original case diary? Or
Lordship, scan copy.
call for the scan copy of the case diary. And relevant portions of the case record of NDPS case number 1 CL NDPS pertaining to the extension of the statutory period. Right? This will do, I think, CD and documents
and
pertaining to the extension.
We also try to obtain certified copy of the orders.
You can relevant and scan reports, case diary and relevant parts of the case report pertaining to extension. Same order. List the matter on. How much time should we take? Don't take very long. To decide that.
Second week of November, Lordship.
13?
13 and
12, 13.
Lordship.
12 is
12 is a motion date, 13 is the hearing.
Lordship.
13.
Lordship.
obviously.
Highly obliged, Lordship.
The accused is behind the bar for last 43 days, your lordship. CD was called for. 15 case diary not received, my lord. Any short date may be fixed.
Is in custody. No.
Can it be on 10th, your lord? Yes, sir. 10, 11. 10th. 10th.
10.
Yes, lord.
Okay. No, it comes.
10, 8.
If it comes, it's
10,
okay.
yes, 10, 11.
Allegations are little, no?
Yes.
Your side. Case diary is not yet received. Issue fresh reminder for the case diary of Biswanath Sirali PS case 170 of 25. List the matter on 10/11.
Yes, yes.
Route 16 is a regular bail application and 17 is an anticipatory bail, my lord. Both are tagged together. Here, my lord, I think if your lordship takes item number 16, petitioner was arrested on 31st of August, and as of date, my lord, as on today, 61 days in custody. There are two petitioners, my lord. And the FIR lordship will find it page number 16. But the sum and substance of this FIR is that, my lord, one dumper was allegedly converted into a tanker for illegal sale of crude oil. And there was a blast and some suspected crude oils were seized. On that allegation, my lord, these three petitioners, or three persons, my lord.
Were arrested.
Yes, my lord. The lordship turns to page number 17.
Yes.
Three persons were apprehended and produced before the
court, my lord. Here this bail application is with regards to serial number 1 and 2, Jalil Ahmed and Hamid Ali. Now, my lord, thereafter, if your lordship turns to page number 20, fight order dated 31st of August, lordship kindly turn to page 21. On the basis of an application filed by the IO, additional sections of 3, 4, 5 of Explosive Substances Act and section 7 of the Essential Commodities Act were also added. Initially, these two only Petroleum Act and offense under BNS was registered, my lord, in the FIR. Now, my lord, if your lordship turns to page number 29, is the part of Jamabandi, my lord. Here, the place which is alleged to have been used for conversion of illegal storage of crude oil and conversion, my lord, that land belongs to one Shiraz Ali. And the vernacular person at page 30, my lord. Shiraz Ali is the father of the petitioner number 1 of item number 16 and petitioner number 1 in item number 17, my lord. Shiraz Ali. And lordship kindly turn to page 32.
Agreement.
Yes, my lord, on the 27th of August 2023, by way of executing a lease deed, authorized lease deed, that land, particular land, which schedule lordship turns the same, my lord, that land which is mentioned in the Jamabandi, it was leased out to one Sanjay Sharma.
Okay.
And since then, my lord, that lease agreement is still subsisting, my lord. It is effective till 31st of December 2026. Lordship kindly turn to page 33, my lord. But this lease agreement is still subsisting, my lord, till December 31st, 2026, and it is in possession of the lessor, my lord. The father of the petitioner, number 1, has already handed over, my lord. As per the term of lease, the second party has paid amount so and so, so and so. Second party is already handed over the position to the lessor, my lord. And my lord, on the basis of this agreement, my lord, page 36, in respect of item number 17, this honorable court also allowed anticipatory bail, pre-arrest interim bail to the petitioners in item number 17. And by it, my lord, page number 39, although there were 3 accused were arrested, 1 person was granted bail, but in respect of the petitioners, the bail was rejected, my lord. Lordship kindly turn, my lord. Although this point was placed at 40, lordship kindly turn, my lord. Lordship has got it, my lord.
Yes.
The last paragraph,
Yes.
learned counsel for the accused persons, namely Jalil Ahmed and Hamid Ali, submits that the accused persons, namely Jalil Ahmed and Muhammad Hamid Ali, have been falsely implicated in the present case without any substantive material linking them to the alleged offences. Learned counsel also submits that though the FIR alleges illegal storage of crude oil in a godown at Singhadwar, the said premises belongs to the father of the accused who had already rented it out to one Sanjay Sharma from Himachal Pradesh since 2023 for his independent business activities. And as such, the accused persons has no control and access to the said godown. But this plea was also taken before the court, my lord. But it was rejected. But in respect of the other accused, my lord, that lordship page 42, the same order reflects, my lord, considering the nature of allegations against the petitioner, his professional background, so and so, so and so. Ashraful Rahman, my lord, out of 3, his bail was allowed, my lord. So basically, my contention is that, my lord, whatever has been committed, my lord, that has been done, perhaps, my lord, by the lessor, my lord. There is no involvement of the petitioner in the alleged offence. And till as of now, 61 days in custody, my lord. Already investigation has been progressed and statements has been recorded. So considering the length of detention, my lord. And in respect of item number 17, initially, my lord, we were not aware about the addition of additional sections.
Okay.
Then we have filed an IA immediately after interim order was passed, we have filed an IA before this honorable court to bring on record regarding addition of, that was allowed. Pursuant to that, my lord, this has been amended.
Who are the petitioner in this case, in the AB?
AB, my lord, one Abul Ali, he is the brother of petitioner number 1 in item number 16. Both of their father is Siraj Ali, who is the registered owner of the land, in respect of which the,
Lesser.
yes, my lord, the lesser. And my lord, police has already taken custody of the original, that lease agreement, whatever was there, my lord. And any document that has been seized also, my lord.
Anyway, one for this.
Yes, my lord, I have received the case diary, my lord. Regarding the present petitioners, my lord, Jalil Ahmed in the petitioner number 1 is in the BA
BA.
and one Hamid Ali. And my lord, anticipatory bail Abul Ali, there are
Two persons.
two persons.
Two persons, two
But
persons.
regarding in the anticipatory bail second person, I have not found so much of materials against him. Regarding other persons, my lord, there are sufficient material against the accused person, my lord. Jalil Ali and Abul Ahmed, they are running a racket, my lord. When the fact, when those facts come into my lord, light, when the burst took place in the godown of the petitioner, my lord. And this Jalil Ahmed and Abul Ali, they are, my lord, carrying out this business, storing this crude oil, highly inflammable, my lord, and hazardous substance in a, my lord,
Very strict.
in a
protocol to handle
residential
these
area,
things,
my
no?
lord. Thereafter, my lord, considering the gravity of the nature 345, section 345 of the, my lord, explosive substance act, my lord, added. And there are two persons, my lord, seriously injured, my lord, two laborers working there, my lord. They are now still, my lord, undergoing treatment. And from the materials, my lord, here, my lord, I have found that the racket is going on. They in fact created underground chamber in the godown, my lord, for storing that crude oil, my lord. Thereafter, my lord, some pump also, my lord, recovered by the police by using that pump, my lord. He, my lord, thereafter, my lord, loaded those crude oil to the various tankers and thereafter, my lord, transporting to various places, my lord, in Assam, my lord. So, my lord, from the materials available till now in the case.
Jalil Ahmed and Hamid Ali.
Jalil Ahmed and Hamid Ali, there are materials. Hamid Ali is the associate, and Jalil Ahmed and Abul Ali, who are the main owner of the Godam, my lord, who are mainly running the entire business. And Hamid Ali is a close associate of Hamid, my lord, Jalil Ahmed and Abul Ali. Regarding that aspect, also there are materials. And regarding second person in petition number 3, I have not found so much materials
But
till now.
Abul Ali is there.
Till now, my lord.
Abul Ali.
Abul Ali, there are materials, my lord. And
They were granted interim.
the interim, my lord, at that point of time granted, but considering the materials available on record, my pair before.
When this BA, when were you arrested?
31st of August, my lord, 61 days as on today, my lord.
And regarding the, my lord, I would like to point out Sanjay Sharma. Who is the Sanjay Sharma? There is nothing in the case diary. And original, my lord, tenancy agreement, that is not in the case diary. And trial court order, my lord, specifically reflected. At that point of time, they have not produced any, my lord, that tenancy agreement before the trial court at the time of, my lord, filing application for bail. It is further, there is no materials to indicate the Ellis Godown was not under the possession of the accused person as claimed by the learned counsel. That is specifically mentioned in the trial court order.
Abdul Jalil had some sustained injuries, one of the petitioners.
No, my lord. Abdul Jalil, his name is also Abdul Jalil, my lord.
Also same name, but
Yes.
it's a different person.
One Abdul Jalil and Mujakir Ali, in two injured person, my lord.
This petroleum, these things, these are very lay persons cannot handle. These are strict SOPs there
Yes,
to handle
yes,
these things.
yes, unauthorized,
If we handle,
absolutely
they may
illegally.
always burst.
Illegally, unauthorizedly running this, my lord, godown, my lord, they in fact, my lord, storing all these crude oils, my lord, by creating underground chambers, my lord, this is very serious offense, my lord.
Well, whatever offense has been committed might have been committed by the lesser, my lord.
Not by the lesser, my lord, who is
The lessee, my lord,
them, my lord.
No, that is also one.
That is nothing.
My lord, that, in fact, my lord, my specific instruction is that the original lease agreement, notarized lease agreement is in the custody of the police, my lord, my specific instruction.
But it should have been no, in the diary. It's not in the diary.
No, not in the diary, my lord. And my lord, there are injured persons, my lord, photograph is also there, my lord.
Must have suffered burn injuries.
Yes.
They must have
I'm
suffered
not
burn injuries.
denying that there was no blast or something, but my contention is that the petitioners are not involved, my lord.
Morning, case 36, it will be a BA, 60, I think. Para, para, page 36. I got order. First, 1, 2, 3, 4. 4 like.
We'll also call.
No, 6, 9, 10. Page 36.
Malay, address.
Right, alert. Denying their involvement in the alleged offences, the learned counsel submits that the 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 land where the alleged incident is stated to have taken place belonged to Chirag Ali,
Siraj Ali, man.
Siraj Ali, the father of the petitioner number 1, and that he had leased out the same to one Sanjay Sharma from Himachal Pradesh. Therefore, and the said lease is still subsisting till 31st December 26.
My lord,
And therefore, 31st December
Yes.
26, and therefore
2026.
26, right? And therefore, the
And also
any
consider
operations on that land is within the knowledge of the that lessee rather than the family of the petitioner number 1. It is submitted by the learned counsel that 2 co-accused were granted interim bail.
My lord, I
by
would
the
just like to point out one thing, my lord, regarding interim bail which was granted to Abul Ali. Otherwise, he has not appeared before the IO till date, my lord, after obtaining interim.
No, I'm
And-
just referring.
Yes, I am just pointing out to your lordship.
My lord, to that effect, my lord, I am just responding. I have filed an additional affidavit on which date he has went and on. the
And
extra-
regarding Ashraful, my lord, who was granted bail, my lord, from the evidence I have found that he is the, my lord, media person. He took an amount of 6 lakhs from the main accused for not publishing all these materials in the. media.
Which one? Ashraf?
One Ashraful, who was granted bail by the trial court,
Acha. Regular bail by the trial court.
regular bail by.
The case diary has been received. The present 2 accused persons seeking bail hearing were arrested on 31/8/2025. And it is fairly submitted by the learned petitioner counsel that in the context of additional penal provisions of Explosive Substances Act. And what it was added.
Essential Commodities Act.
And
Section 7.
the Explosive Substances Act, the applicable
3, 4, and 5.
statutory period would be 90 days. However, the learned counsel submits that the petitioners have already spent considerable time in under trial detention. On the other hand, the learned additional PP strongly opposes the bail and submits that on the basis of the investigation conducted so far as reflected in the case diary which has been received. It has been found that the accused persons are involved in running a racket of selling such, storing and selling such petroleum products illegally. And that in the investigation is also found creation of a special chamber in the godown for storing such crude illegally. And that these activities came to light only when supposedly converted dumper vehicle containing such crude oil blasted. You are opposing the bill at this stage?
Yes.
The learned additional PP submits that investigation is going on and perhaps the bail should not be considered at this stage. Can I have a look at the case there?
Yes, yes.
It is also submitted by the prosecution that the lessee named Sanjay Sharma of Himachal Pradesh does not find any reference in the investigation. And that the said lease deed is also not available in the case diary, nor any such lease deed found by the investigation so far. It is submitted with the prosecution that the alleged offences are serious in nature and of an organized nature. The contentions of the prosecution in the backdrop of the materials revealed by investigation cannot be brushed aside lightly. And despite the length of detention, considering the nature of the alleged offences, the materials revealed, and continuance of the investigation, the bail stands rejected at this stage. Return back the case there. As far as the AB is concerned, since there is no material against the other person, so let him be made absolute. But
Regarding my lord, item number, anticipatory bail against petitioner number 1, there are sufficient materials.
materials.
Against petitioner number 2 also, at this point of time, I do not find
so
any
far.
sufficient material, but
For
investigation is going on.
The land council has submitted that petitioners were granted interim bail on 3/9/2025.
Lordship, I'm just trying to respond, the statement that they have not cooperated with the investigation. I have filed an additional affidavit on which date the petitioner went, that is on record, my lords, but their statement has not been recorded.
I did have submission of the bill. And the person to which they have appeared before the IO. And in the context of which an additional affidavit has also been filed. It is fairly submitted by the learned additional PP that the investigation so far has not found much incriminating materials with regard to petitioner number 2, Rabul Ali. Good stuff. However, the investigation has found sufficient incriminating materials against petitioner number 1, Abul Ali alias Abul Ahmed, who in collusion with the other co-accused have been found to be involved in running a racket of this nature of illegally storing crude oil and at a great risk to persons involved and also to the surroundings. It is submitted that the incident came to light only when there was a blast in a dumper supposedly converted for storing such crude oil, which is an inflammable and hazardous substance. In the given facts and circumstances and the materials revealed, perhaps it may not be justified to confirm the anticipatory bail with regard to petitioner number 1, and therefore the interim with regard to petitioner number 1 stands vacated, thereby rejecting his bail prayer for pre-arrest bail. However, the interim pre-arrest bail granted to petitioner number 2, Rabul Ali, by order dated 3/9/25, is hereby made absolute, subject to the condition that he shall cooperate with the remaining investigation and shall not handle temporarily. The bail petition stands disposed of on the aforesaid lines. Return back the case. Investigation complete.
18.
15, 17.
Maybe legislation. It is a 483 value petition matter. The petition is behind about 58 days. The statutory period is 60 days. CDS confirm.
There is 59 days today.
60 days.
60 days of
60
my lord.
60
Today is 59 days. He is arrested on my lord. That is 28 of my lord. My lord, September 3rd, my lord. September 3rd. Today, my lord, 59.
Robbery.
My lord,
Theft, no?
safe, my lord. 305, 331.
third so and so, 483 bail applications. Grant, used seeking bail was in connection with dispute PS 721 of 25 under section 4. The accused was arrested on 3/9/25. The learned additional PPK Bosa Fairly submits that investigation, case diary has been received. Revealing that investigation is not yet completed, though it has progressed. And that the applicable statutory period is 60 days. The learned counsel submits that the petitioner, having been arrested on 3/9/25, has completed 59 days as on today. Let him go and then on this one. And, considering the progress of investigation and the length of detention vis-à-vis the applicable statutory period, dash, the accused is hereby allowed to go on bail of rupees 30,000, 30,000? Yes, 30,000 with one security of the like amount to the satisfaction of the concerned learned court, CGM Kamrup Metro, and subject to the condition that operate with remaining investigation, not hamper temporary evidence, and shall not commit any illegal activities.
Obviously.
Until considered. Okay.
Obviously.
23.
22.
May I please your lordship? One of the petitioner was arrested on 13/8/2025. Today is 80 days, both behind the bar, my lord.
POCSO matter, my lord, notice served.
Updated.
Yes.
This week, learned and just learned additional PP submits that the case diary has been received, but it needs to be updated. Accordingly, the case diary may be returned back and procured again with up-to-date investigation. The interim bail granted to the petitioners by the order dated 26/9/25 stands extended till the next date. of this.
Two orders.
1411.
Two orders, my lord.
Who orders it?
15/9/25 and
Oh,
26/9.
two interim orders.
Two interim
Oh.
orders.
15/9/2025 and 26/9/20. Will I be able to decide on?
On 1411, Lordship.
Hmm?
1411.
Hi. 14/11.
25, Lordship. May it please your Lordship. Your Lordship, the petitioner of your Lordship is a 21-year-old boy, Lordship. He was having an affair with the girl, Lordship, and that thereafter the present case was lost by the father of the girl.